Take a moment for people to clear, and then we'll take Nelson versus Wade. All right, good morning. Are you Mr. Friedrich?
Good morning, Your Honor. Paul Friedrich for the plaintiff, William Nelson.
All right, good morning. Ms. Lane, are you on the phone?
Yes, I am. Good morning, Your Honor.
All right. So I'm sorry you had to wait through all of that this morning, but at about $10,000 an hour, I felt like I couldn't have all those people wait. So I apologize for the delay. Mr. Friedrich, you can go ahead.
Good morning. Thank you, Your Honor. For the record, my name is Paul Friedrich, and I represent the plaintiff creditor in this adversary proceeding, Mr. William Nelson. And this is Mr. Nelson's motion for summary judgment, seeking to accept from discharge a state court judgment for willful and malicious injury caused to Mr. Nelson. I think the facts are fairly straightforward, and as a matter of law, it is our position that they cannot be disputed or relitigated in these proceedings on several grounds. Number one, issue preclusion, and then also under the Rooker-Feldman doctrine, which I also heard mentioned in the earlier proceeding today. And so that really doesn't leave a whole lot to discuss as far as the facts of this case. They are, again, fairly straightforward. The state court judgment speaks for itself. It does contain an express finding that Mr. Wade acted purposefully and willfully in publishing these false defamatory statements that ultimately caused significant injury to the plaintiff. And the case law in the Western District of Washington and in the Ninth Circuit is pretty clear. When there has been a prior state court finding of defamation per se, and particularly when the defamation here is so egregious in nature, that it does support a finding of willful and malicious injury. I think the willful element is a little bit more elusive, according to the case law, than would be malicious. Most of the case law, again, in the Western District of Washington and in the Ninth Circuit, basically says, as far as the malicious element is concerned, that once you have a judgment on the issue of defamation per se, you've satisfied the first three elements of maliciousness. And then it's incumbent upon the debtor to establish just cause, which is in the nature of an affirmative defense. Now, again, under the Rooker-Feldman doctrine, the debtor is stripped of that opportunity. They can't come into court and relitigate affirmative defenses that would have been available or that were available to the debtor in the prior state court action. So the debtor is precluded under issue preclusion principles, but then also under the Rooker-Feldman doctrine from establishing just cause or excuse. Now, let's just assume for the sake of argument that neither of those are applicable here in the first place. The debtor can't establish just cause or excuse in any event, because how could anyone establish just cause or excuse for falsely accusing someone of sexual assault, rape, running a child sex ring, attempted murder, and say that you had just cause or excuse to falsely defame someone in that manner? There is no just cause or excuse to publish false allegations of that nature. And he has not offered any. And one thing that I would like to point out to the court, which did not become apparent to me until preparing for this hearing, is that Mr. Wade's declaration, which is the sole evidence submitted in opposition to plaintiff's summary judgment motion, it is not stated under the penalty of perjury. And under U.S. Code 28, Section 1746, there are clear rules for submitting a declaration to be used as evidence in a court of law. And Federal Rule of Civil Procedure 56 is also very clear as far as what types of evidence can be submitted in opposition to a summary judgment motion. And really what this is just part of a larger pattern in practice of Mr. Wade, failing to comply with his duties as a litigant in either state court or in these proceedings. With regard to these proceedings, it is relevant for the court to note how the state court ultimately got to the default judgment. And it was because of his repeated abuses of the judicial process. The court found that he was repeatedly and purposefully lying under oath in the state court defamation action. And again, this is just all a continuation of that. It's become part of a pattern in practice. And now he wants to use the bankruptcy code to shield himself from this deplorable conduct. And the bankruptcy code has a purpose. It is to protect the honest debtor. But it was not designed to protect the dishonest debtor. And I think this is a textbook example of where a debt should be exempted from discharge. I was not able to find a case all square with the nature of the defamatory allegations that were made against my client. The closest I could find was a case actually arising out of this court before Judge Barreca in Ree Robinson. And that involved defamatory statements made online falsely alleging sexual assault. And in that case, the court exempted from discharge the judgment arising out of the defamatory statements that were published online. What we have here are statements that were published online that are far more egregious than merely false allegations of sexual assault. Because again, we have allegations of attempted murder, drug use, assault, running a child sex ring. And Your Honor, I could go on and on and on, but I think the case law and the facts, particularly when there is an express finding that the debtor acted purposefully in order to ruin this individual's personal and professional reputation in a small community like Bainbridge Island. When there is that express finding in the final judgment, I don't think there can be any dispute that the willful element has been satisfied. And so at this point, I will defer to Your Honor for any questions. I'm more than happy to answer them. And I would like to reserve a few minutes for rebuttal.
Yeah, for sure. No questions right now. Thank you.
Thank you.
Ms. Lane, you can go ahead.
Yes, good morning, Your Honor. I'm Erin Lane. I represent Wade Houston, the debtor and the defendant in this matter. Plaintiffs bring their motion for summary judgment before the court and claim issue preclusion because the evidence establishes that one, defendant injured plaintiff by publishing defamatory statements, two, defendant disobeyed a court order to comply with discovery, which is not part of their complaint, nor a part of 11 U.S.C. 523A6. 3, defendant intended to injure plaintiff, and 4, defendant's conduct towards plaintiff was malicious. Issue preclusion may provide a proper basis for granting summary judgment. However, plaintiff has failed to meet their burden of proof because he fails to have pinpointed the exact issues litigation in the state court action and introduce a record establishing the controlling facts. To exclude a debt from the bankruptcy discharge, the willful and malicious nature of Mr. Wade's actions must each be proven independently. Bankruptcy laws define willful as a deliberate or intentional injury, not merely a deliberate or intentional act that leads to injury. Merely showing that someone committed a conscious act that resulted in an injury is not sufficient. The act must be shown to have been done with the intent to cause the injury, and that this is where Mr. Nelson fails, and a genuine issue of material fact exists. Mr. Nelson claims Mr. Wade made his statements with specific intent to injure, and I quote, me and my personal and professional reputation, but does not submit any evidence before the court as to Mr. Wade's intent. He only submits his declaration and attaches the findings of facts and conclusions of law, which does not say anywhere regarding Mr. Wade's intent to injure Mr. Nelson. It is completely silent. No evidence submitted to this court or to the state court links Mr. Nelson's injuries directly to Mr. Wade's intent to injure. In Mr. Wade's response, 2 on-point cases are noted. Shanghai versus Schrader and Wentz versus Adkin, both dealing with state court judgments against a debtor for defamation per se. The BAP in Shanghai concluded the court on summary judgment could not infer that Shanghai acted with requisite willful intent solely because the state court default judgment included an award of punitive damages. There, the debtor accused the plaintiff of sexually assault. They later texted the plaintiff that they were sorry and that the posts made to Facebook, it was a video post, were actually false. There, the court that say that the injury inflicted upon the plaintiff in that case was done willfully for purposes of 523A6. The state court judgment standing alone did not establish Shanghai acted willfully. The state court judgment in this court standing alone also does not establish Mr. Wade acted willfully to cause the injuries Mr. Nelson claims to have received the sexual assault cases, Robinson, getting that confused. Read a lot of cases this morning. The state court judgment in the court standing alone also does not establish Mr. Wade acted willfully to cause the injuries Mr. Nelson claims to have received based on Mr. Wade's actions. There is no evidence linking his injuries to Mr. Wade's intent to cause those injuries. In the Wentz, the court focused on the debtor's subjective intent when determining the willful element. There, the debtor made posts on a blog. He further explained what he was doing on the blog, how he obtained the information, and how he used those blogs to pass on information he had heard. The bankruptcy court there determined that the debtor lacked the subjective intent to inflict the intent for the injury. The debtor's testimony, he was simply passing on information that was basically gossip to him, was his intent. He was informing the public. The court concluded the debtor just acted stupidly and foolishly, but did not act with a willfulness to injure the plaintiff's business. Here is the same. Mr. Wade is simply passing along information to the public to make sure they are safe. He did not intend to injure Mr. Nelson's business or him personally. It is repeatedly stated by Mr. Wade in all court documents submitted by the plaintiff in his declaration. Plaintiff's counsel state that defendant was provided a full and fair opportunity to litigate the state court issues. However, the motion the final judgment was based off was never served on Mr. Wade. We have provided such documentation and evidence to this court in our response. Mr. Nelson's failure to provide Mr. Wade with proper service resulted in Mr. Wade not being able to be a part of the final adjudication, and anything in the final judgment is purely off of Mr. Nelson's accusations. Nowhere in Mr. Nelson's complaint is it alleged Mr. Wade abused the judicial process. Trying to vacate a final judgment because of improper service is not litigating the merits found within the final judgment. Vacating a judgment is stating to the court that due process was not complete. In plaintiff's motion for summary judgment, he relies heavily on a case, Federal Deposit Insurance Court versus Daly, which is a case brought under 523A2A, which deals with fraud. That case is vastly different from the one before the court and should have no persuasive authority, as the elements under 523A2A and 523A6 are different. It wasn't until plaintiffs replied that they actually focused on the elements necessary to have a debt excluded from discharge under 523A6. In their response, they relied on a couple of cases which differed greatly from the one before the court. Robinson's case differs here in that the case there, the debtor admitted the posts to Facebook were false to the plaintiff prior to her even filing for bankruptcy. The debtor, out of retaliation, posted to a personal account a video and accused the plaintiff of sexual assault, later sending a text message to the plaintiff apologizing for them that they were false. The court specifically pointed out that on appeal, the bankruptcy court did not believe Mrs. Robinson's testimony that she thought the allegation was true at the time she posted the video because of the apology text message. This is not the same as the case here. First, Mr. Wade's statements are true. He has maintained they are and provided plaintiff and this court with evidence supporting his statements. Hagel also differs. There, the debtor made statements all over the internet about the plaintiff over a substantial period of time. Statements made directly to her employer and on numerous forums. He took it even further and hired a private investigator who had, quote, complete access to the plaintiff's home. His widespread internet remarks, coupled with his additional actions, such as hiring the private investigator, led the court to uphold the bankruptcy court's ruling on appeal. This is vastly different from the case before you. Mr. Wade's statements were only on a news and media blog he created to warn the public to keep them safe from men who have done bad acts in the community. There, the court satisfied the two prongs of Jarek because of the libelous act. The third prong was met because the statements were directed at plaintiff's professional reputation, which differs from Mr. Wade because he provided information that was true and already known by many in the community on one media and news blog he created without the intent to injure Mr. Nelson's professional personal life. He didn't do anything else.
Let me interrupt for a minute, if I can, because, I mean, you keep saying or arguing that what Mr. Wade said was true, but for the purposes of this motion, I mean, they're not true, right? I've got a state court judgment that says they're not true. They're lies. That's what you're appealing in the state court and trying to get overturned. But for me, for this motion, they're not true statements. Don't I have to take the findings of the state court as they come?
Not according to the Jarek prongs. So, yes, there is a judgment that says that they are untrue, but there are four prongs in Jarek. And I was just about to get to the fourth one.
Yeah, I mean, that's fine. You can argue Jarek. I'm just saying I understand Mr. Wade does not agree with what the state court found, but in these preclusion matters, I mean, what we do is we don't get to change what the state court did. We take what the state court did and see if what it did matches what needs to be proved under section, in this case, 503A6, but whatever section it might be in any given case. So you don't really get to relitigate the found facts. What you need to do to win is essentially say those facts don't meet all the elements of 523A6, and therefore there's something that needs to be tried.
Right, and though it's the malicious injury aspect that needs to still be tried that was not litigated within the state court action.
Yeah, you can continue.
Okay. So this leaves us with the fourth prong without just cause or excuse. Plaintiff wants this court to have a per se rule that there could never be just cause or excuse for defamation. However, that is not the law. Just cause or excuse is an affirmative defense. The element that Mr. Wade intended to cause injury or likely knew that injury would occur was never litigated in the state court. In a case before the court, Mr. Wade has presented through his declaration the reasoning behind his blog. Also, the reasoning behind his blog was submitted by the plaintiff's declaration in Exhibit C, which is the answer to the state court complaint. This does not add up to Mr. Nelson's allegations that Mr. Wade intentionally caused harm to him, just like in the Wentz court. Again, just as an intentional tort like defamation per se does not give rise to the malicious element required under 523A6. Further, the issues before the court were not actually litigated in the state court. The final judgment was made on default. Yes, before the court, you do have to follow the order that is before you. Plaintiff is relying again on the Hagel court. If we do that, then this court cannot determine that the willful and malicious were actually litigated in the state court. The Hagel court defined actually litigated as when the parties must have enjoyed a full and fair opportunity to litigate that issue in the earlier proceedings. Mr. Wade was not provided a full and fair opportunity. Mr. Wade has stated in his declaration his blocked attempts to provide discovery responses to plaintiffs. He was not provided notice of the final hearing, which led to judgment. He was provided this court through his declarations the truth of the statements made. Declarations served were improper, and Mr. Nelson has not provided evidence that the malicious element was actually litigated in the state court, nor evidence to it. On behalf of Mr. Wade, I respectfully ask the court to deny Mr. Wilson's motion for summary judgment.
Why do you think? Explain to me why you think he didn't get a full and fair opportunity to litigate in state court. He participated for a length of time, and the reason his participation was cut off was because the state court found his conduct sufficiently inappropriate to strike his pleading and enter a default. I mean, how is that not participating?
So Mr. Wade did try to participate, but was completely cut off by plaintiff and his counsel the entire time. He did submit discovery responses to plaintiff, handwritten. They said that they never received it. He then sent a copy of that to the plaintiff's counsel. They said it wasn't proper formatted. When he found that out, then he submitted a third one typed out to plaintiff's counsel that was finally then considered accepted, except they said that they were not complete because they didn't identify witnesses' name, address, phone number, except when you read the actual interrogatory and the definition of identify, it's to provide the known information. And he provided all known contact information that he had. But for some reason, that was determined that was an incomplete. And then after he actually submitted the third response to discovery, which included a list of witnesses, those witnesses started to contact Mr. Wade and said that they were contacted by Mr. Nelson and they didn't want to be a part of the lawsuit. So he tried. He was just blocked numerous times. He was a pro se in the state court trying to navigate the judicial process himself. And after reading a lot of what happened within the state court, reading a lot of the hearings and what actually happened, I'm actually really surprised that there was an actual final judgment brought by default, and also that the motions to vacate were not granted.
So what's the status of the appeal at the moment? Do you know?
It's still ongoing. The December 29th letter that plaintiff brought up in the motion for summary judgment, we actually responded to that in Mr. Wade's declaration filed with this court.
Yeah, I think that was before we were here last time. But I mean, I'm just trying to figure out if anything has happened since then. Is there a briefing schedule? Is there anything?
If I may.
No, not yet.
I think Mr. Friedrich maybe has a different point on that. Go ahead.
Yeah, thank you, Your Honor. I did anticipate this issue would come up at today's hearing, and so I checked the appellate docket to see what the briefing schedule was, if any. And Mr. Wade's appeal brief was due yesterday. I checked with David Horton over in Kitsap County, who is the attorney handling the appeal on behalf of Mr. Nelson. And he confirmed in writing this morning that Mr. Wade did not timely serve his appellate brief. that was due yesterday, and there is no indication on the court docket that it was filed with the court either. So
the appeal's pending, but it may be tenuous.
This is precisely why we did not want to stay of this action, because for all we know, the appeal could go on forever.
So, Ms. Lane, is Mr. Wade, is he pro se on that appeal, or are you involved in that?
No, he's pro se.
Okay. Any further presentation, Ms. Lane?
No.
All right, then I'll let you respond, Mr. Friedrich, if you like.
Thank you, Your Honor. If Your Honor has any questions, I'm more than happy to address them. I'll try to keep things very brief. The defendant's opposition is essentially just an effort to relitigate matters which the defendant had a full and fair opportunity to litigate in the state court action. And he now tries to blame, apparently, the plaintiff's attorney in the state court action for cutting off his ability to litigate. Well, that simply is not supported by the record in the state court action. The state court in Kitsap County Superior Court made extremely detailed findings in its order of default, precisely why it was entering that order. And it was because of Mr. Wade's repeated lies made under the penalty of perjury at his deposition, and numerous other instances in which he failed to comply with the court's prior orders. As far as service is concerned, there is no obligation to provide service on a party once an order of default is entered. That's precisely what being in default means. It means that the party can now proceed to judgment without any further notice to the party who is in default. And even if service were actually an issue, the court in Kitsap County had an opportunity to hear Mr. Wade on numerous occasions. He filed 2 motions to vacate. Both of them were summarily denied. Now, as far as the willful and malicious injury requirements in order to exempt this debt from discharge, the defendant repeatedly overlooks and refuses to acknowledge that the state court did make an express written finding as to Mr. Wade's intent. And not only his intent, but his specific intent and what his intent was. And that was to run Mr. Nelson off of Bainbridge Island. And that is unmistakable evidence of a willful intent to cause injury to the plaintiff. And that was an express finding made by the Kitsap County Superior Court. But let's just assume, again, for the sake of argument, that the court's written findings didn't contain that express finding as to Mr. Wade's intent. That is not required under the case law. It can be, inferred based on the circumstantial evidence. And again,
at summary judgment,
when someone has made statements like this that are deemed as a matter of law to be false, there can be no other reasonable interpretation as to what someone's intent was in making statements alleging someone of rape, alleging someone running a child sex ring, alleging someone of attempted murder. But again, we have an express written finding in the court's order, and so we don't need to rely on circumstantial evidence. And based on the express finding, and based on the express finding that there were damages caused, that this was a wrongful act intentionally done, that did in fact injure and cause substantial injury to Mr. Nelson, the court should enter summary judgment. This is not a case that should go to trial. Mr. Wade has had a full and fair opportunity to litigate these issues, and the Kitsap County Superior Court's final judgment precludes him from relitigating them here. And so we would ask that Your Honor enter summary judgment.
All right, thank you very much. Ms. Lane, anything else this morning?
I want to touch upon the quote that Mr. Frederick is referring to, which is that he wanted to run Mr. Nelson off the island. I have been streaming through everything submitted by the plaintiff this morning, trying to find where that quote even came from. I cannot find it. I don't know who said it. And there's no evidence to back who actually even said that up. It's just some quote that was prepared in the findings of facts and conclusion law that was actually prepared by plaintiff's counsel. And the statements that were published on the media and news blog actually there was nothing about a child sex ring or attempted murder. And I believe the court needs to focus on whether or not the subjective intent was actually litigated within the state court. And I think everything before the court shows that it was not.
Are you finished?
Yes.
Hard for me to tell when you're on the phone. You got to tell me when you're done.
Sorry about that. All right.
All right.
I'll remember that from future.
It was your motion, Mr. Friedrich, so you can have the last word if you like.
Oh, well, if Your Honor is having any trouble finding the quote that I continue to rely upon.
No, I know where it is.
Okay. That's all, Your Honor.
All right. Thank you. All right. All right. I'm going to grant the motion in part and deny the motion in part. Under Rule 56, summary judgment's appropriate where there's no genuine dispute as to a material fact, and the movement is entitled to judgment as a matter of law. Under Anderson versus Liberty Lobby, 477 U.S. 242, 1986, the evidence of the party opposing summary judgment is to be believed, and all reasonable inferences are viewed favorably to that party. The inquiry is whether the evidence presents a sufficient disagreement to require submission to a trier of fact, or whether it is so one-sided that one party must prevail as a matter of law. This summary judgment motion is based on the results of a pre-petition state court lawsuit that resulted in a judgment in favor of the plaintiff and against Mr. Wade in the principal amount of $500,000. The state court judgment is on appeal, or perhaps more precisely, the denial of a motion to vacate that judgment is on appeal. Regardless, a pending appeal does not impact the finality of a judgment for preclusion purposes. State v. Harrison, 148 Washington 2nd, 550, 2003. The plaintiff's issue preclusion arguments are based primarily on the September 27, 2021 findings of fact, conclusions of law, judgment, and permanent injunction, which I will refer to as the judgment. I reviewed the judgment carefully and am required to accept the state court's findings and conclusions. I then am required to determine whether those findings and conclusions are sufficient to prove all of the elements of the plaintiff's claim under Section 523A6. Section 523A6 accepts from discharge debts for willful and malicious injury by the debtor. To prevail on a Section 523A6 claim, the creditor must establish a deliberate or intentional injury, not merely a deliberate or intentional act that leads to injury. Kawaha versus Geiger, 523 U.S. 57, 1998. Negligence or reckless conduct is insufficient. The willful injury requirement is met only when the debtor has a subjective motive to inflict injury or when the debtor believes that injury is substantially certain to result from his own conduct. In re Ormsby, 591 F. 3rd, 1199, 9th Circuit, 2010. The debtor is charged with the knowledge of the natural consequences of his actions, and the court may consider circumstantial evidence that tends to establish what the debtor must have actually known when taking the injury-producing actions. The malicious injury requirement has 4 elements. 1, wrongful act. 2, done intentionally. 3, which necessarily causes injury. And 4 is done without just cause or excuse. Ormsby. Malice may be inferred based on the nature of the wrongful act. The plaintiff has the burden of proof to establish each element of a 523A claim by a preponderance of the evidence, and issue preclusion principles apply in bankruptcy discharge disputes. Grogan v. Garner, 498 U.S. 279, 1991. Issue preclusion prevents the relitigation of all issues of fact or law that were actually litigated and necessarily decided in the prior proceeding. In re Cogliano, 355 BR 792, 9th Circuit Bankruptcy Appellate Panel, 2006, and Robbie v. 5 Platters, 838 F. 2nd, 318, 9th Circuit, 1988. In applying issue preclusion, I used the state law that was applicable to the underlying litigation. In re Norbach, 67 F. 3rd, 798, 9th Circuit, 1995. Here, that is Washington state law. Under Washington law, the elements of issue preclusion are 1, identical issues, 2, final judgment on the merits, 3, the party against whom the plea is asserted must have been a party to or in privity with a party to the prior adjudication, and 4, applying issue preclusion will not work in injustice. In re Estate of Hamilton, 181 Washington 2nd, 802, 2014. The application of issue preclusion does not work in injustice where there is a full and fair opportunity to litigate the issue in a neutral forum. Raines v. State, 100 Washington 2nd, 660, 1983, and Neff v. Allstate Insurance, 70 Washington Ave, 796, 1993. Reasonable doubts about what was decided in the prior action are resolved against applying preclusion. In re Lopez, 367 BR 99, 9th Circuit BAP, 2007. Summary judgment is granted as to the malicious prong of Section 523A6. The first 3 elements of that prong, namely a wrongful act done intentionally which causes injury, were unquestionably determined in the judgment. The judgment provided that Mr. Wade published defamatory statements about Mr. Nelson. Those statements were false. Those statements were defamatory per se, and Mr. Nelson suffered $500,000 in damages. Those findings from the judgment established that Mr. Wade committed an identifiable and legally wrongful act against Mr. Nelson. Given that determination of wrongdoing, Mr. Wade cannot identify any cause or excuse that would be just. In re Bammer, 131, Fed 3rd, 788, 9th Circuit, 1997. Summary judgment is denied as to the willful prong of Section 523A6. The judgment contains insufficient findings to conclusively demonstrate that Mr. Wade had the subjective intent to injure Mr. Nelson or the belief that injury was substantially certain to occur. The only finding in the judgment related to Mr. Wade's intent is that he made the defamatory statements to run Mr. Nelson off the island. That one finding is not enough to support summary judgment, given the requirement to resolve reasonable doubts about what was decided in the prior action against applying preclusion. It is possible a trier of fact could find that Mr. Wade did not think injury to Mr. Nelson was substantially certain to follow from his actions and believed in the truth of the defamatory statements he made at the time he made them, and therefore lacked intent to injure Mr. Nelson. So that's the ruling on the summary judgment motion. I'm going to go ahead and prepare my own order so the parties don't need to worry about that. Today was also the time I had continued that portion of the motion related to a stay, but I've already issued a new scheduling order. So unless the parties see reason not to move forward here, I think we'll just move forward here. But I did continue that today, so if anyone wants to argue in favor of a stay of this proceeding, why don't you go ahead, Mr. Friedrich?
Your Honor, I am not arguing in favor of a stay of this proceeding.
Ms. Lane?
No, we don't need to stay the proceeding.
All right, then we will just, you have a scheduling order, so we will just proceed in that regard. Go ahead.
One final comment, Your Honor. This motion was based, again, as Your Honor noted, primarily on the findings of fact and conclusions of law contained in the state court judgment. However, we would like to have an opportunity to elicit further discovery for a possible summary judgment motion solely on the willful element.
Yeah, that's all that's left.
And before we go ahead and file that, we would just wanted to get Your Honor's, maybe not blessing is the right word, but just to make sure that Your Honor would not be upset with us if we were to file a motion on this exact same issue supported by additional discovery.
Yeah, I mean, no, I'm not. You're more than welcome to file it as long as it's within the constraints of the scheduling order.
Okay.
And I can't remember when that is, but I think there's still time.
There is.
For summary judgment motions.
There is.
Yeah, I mean, exactly. I mean, obviously it needs to be on a different basis. I don't want to hear preclusion again, but yeah, if you think you can make the case based on other discovery, you're more than welcome to bring that motion and I'll hear it.
Okay.
All right.
Thank you, Your Honor.
And again, I know this is a tough one to resolve, but you should consider it. I know Mr. Friedrich wasn't here last time, but it's still kind of a head scratcher to me how anyone's going to get much out of this given Mr. Wade's financial condition and the likelihood. I guess the other thing that just is crossing my mind on this is a 523A6 claim, which would make it dischargeable in a subsequent Chapter 13 case. So I know the emotions are high here, but I scratch my head a little bit on the economics. So I just remind the parties again that we do have a mediation program if you're interested in using it. I don't require it. You don't have to. But if you're looking for a path to resolve this matter short of trial, it's available to you. So I'll just leave you with that thought, and that's all for the day. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right. That was our last confirmed matter this morning, so we will now be at recess.
All right.